everyone. This is Jody Fomer speaking with Kruse Law Firm. And here with me today is Senior Managing Partner and Owner Mike Kruse. We're here today to talk to you about, about critiquing the critique of the Ontario Criminal Court Remand system. So, with that said, Mike, during the normal times, pre-COVID times, how did the criminal remand system work here in Ontario?
Well, first of all, thanks for joining me today, Jody. And
You're welcome.
appreciate that nice introduction. This is it's strange times, first of all. We're in a stressful time, and COVID is mostly bad for society. But, COVID has caused some improvements in some things, let's face it. And one of the things that's improved, at least, is our Ontario Criminal Court remand system. And let me show you, I've been a great proponent of critiquing the system quietly, at least among the criminal bar, quietly. I'm not one to publicly.
You're always quiet.
But everyone's now critiquing, including the Ministry Attorney General.
Mm-hmm.
So I can come in the open about this.
Yeah.
So let me give you an example of how the remand system used to work in the Ontario Court of Justice and the Superior Court of Justice
Okay.
before COVID hit. So let's take the Ontario Court of Justice. Let's just take a simple case, an assault case.
Okay.
So you're charged with an assault case today, and the police might give you a court date, say, 4 to 5 weeks later.
Remember, listeners, this is pre-COVID. Mike's giving us an example.
That's right. So they give you a court date 4 to 5 weeks, and say you hire a lawyer at week 3. That lawyer would then order the police report straight away. Take your retainer, maybe it's legal aid, maybe it's a cash retainer.
Mm-hmm.
Now they're going to become the lawyer of record. You would not go to that meeting. Not much happened at that court appearance.
No, nothing.
What happened at that court appearance is you'd show up at the lawyer and it would be spoken to for a minute. You'd say, I'm counsel of record, I've ordered disclosure, we just received it, or I'm waiting for disclosure. So I would like 4 weeks, please, so we can either receive the disclosure or review the disclosure. So what would happen, you'd come back in 4 weeks, and in that 4 weeks' time, in the meantime, you had met with your client, you'd reviewed the disclosure, or you didn't have it. Mm-hmm. You gave your tentative legal opinion. Maybe there was missing disclosure. There is usually some piece of missing disclosure. The disclosure is the evidence the police have, the witness statements, the police occurrence reports. They have to turn everything over to you, right?
Right, the paper part of the disclosure, right, Mike?
Right, the paper, but more than the paper, there's...
But then what you talk about could be missing.
All sorts of things could be missing.
What other things, just for our viewership, is part of disclosure?
Well, it's rare that we get, usually they have video statements now in many cases, and it's rare that we get the video statements with the initial disclosure package, and they have to be ordered. There could be so many missing things. There could be, once I read the disclosure, it leads to other avenues. See, the police have to turn over every part of their investigative file.
Like their little notes from their black notebook.
Right. There could be, we may have received 5 of the police officers involved, but there was 8 other officers involved.
We're missing those notes.
Yeah, and sometimes disclosures, thousands of pages.
Or photos of slaps on the face or...
Right, exactly. So disclosure package can range from 50 pages to thousands. A murder case to a minor, depends, right?
So moving along, so...
Yeah, so next appearance, so we come back in 4 weeks. Okay, I'm still missing disclosure, or okay, I tell the justice of the peace, we've reviewed it. Now we need some more time to meet with the Crown. So, okay, how many weeks do you need? I need 4 more weeks.
4.
So it's just a reporting mechanism. You're just going to court and reporting. And then you show back in 4 weeks, I need another meeting with the Crown. Or I was sick and I couldn't meet with the Crown. Okay, Mr. Kruse, by the way, your tie looks lovely. Oh, thank you. There's
Nonsense appearances,
There's nonsense appearances, a lot of nonsense banter that went on too, a lot of joking around. And these appearances would go on sometimes for 3, 4, 5 months. So we're missing disclosure. We need to meet with the Crown. We need to have a judicial pretrial. We need to, get strategies, interview witnesses. So the courts expected you to get a case ready, a minor case, to the point where we're either resolving it
or ready to set
a trial. Their target date was 3 months. Sometimes we met it, sometimes we can't. Depends on the case. If it's missing disclosure, you can't. But the whole point is, all the court appearances was a reporting mechanism to tell the court, and it wasn't even a judge, a justice of the peace, what the heck's going on. And our clients often think, oh, these are very important appearances. They're useless. These are like 19th and 20th centuries before the age of electronics, phones, everything. There's a different, better way to do this. Now, this was all highlighted by, and I'll get into the better way. This was all highlighted, Jody, by COVID, because COVID taught us, look, we don't want
What
all
did
these.
that force us to do once COVID hit, Mike?
Well, when COVID hit, this is an interesting question. The first thing they did, they said, look, we don't want any people in the courtrooms because it's not safe.
Not safe, right?
So what we're going to do is we're going to have, they call them presumptive adjournments, where if you didn't show up,
Just automatically.
they
go over.
automatically went over for 10 weeks.
Okay.
If, and what happened there? Well, if you retained a lawyer, the lawyer could still do the exact same steps that they ever did in your file. The important things don't happen at those court appearances. It's the steps behind the file: getting disclosure, reviewing disclosure, meeting with the Crown, having a judicial pretrial, reviewing disclosure,
It's
getting
like the Wizard of Oz.
right.
It's the lawyer behind the file.
That's right. The lawyer behind the curtain with the client before they get to trial, and then the wizard jumps out and does magic at the trial,
Exactly.
right? You've got it. So you get it, Jody. The remand said, so what that taught us, look, if a matter can go over 10 weeks automatically, why are we having all these court appearances? Everyone already knew this. I've been criticizing it for years. Some people did. Some people criticized a lot. I mean, it was more of a social get-together for lawyers on the morning, every morning before they did the trials.
See who is wearing what.
Beautiful suits and,
What female lawyers are looking the best.
Yeah, I
in
mean,
their high
I
heels.
always had to wear a nice tie. I mean, that's all wonderful, except
Yeah.
I want to get back to work. I want to get back to the office, or I want to do my trial.
Wasted time for the lawyers. To
It
be
was a
there.
waste of time, and we often would then, that was called, in the Ontario Court of Justice, that's called remand court. It's called case management court. The Superior Court of Justice, for more serious cases, same idea, things go over.
Like assignment court.
That's called assignment court. Same idea there. But Superior Court, once a case got to Superior Court, it seemed to move a little bit faster.
I think Superior Court was a little more, no pun intended, but superior than the Ontario Court, because there seemed to be less appearances in the Superior Court in my mind.
That's right, Jody. Now, if you elected, though, straight, in most cases, not all cases, but I would say for most cases that was more efficient. But it still had inefficiencies in that
For
court
sure,
as
yeah.
well.
There still could be streamlining going on there.
So what did this 10-week presumptive automatic adjournment teach us? It taught us, why are we having court appearances every 3, 4, 5 weeks? We can go over 10 weeks. Why can't we even go over more than 10 weeks?
We could
Because
probably go over 5 weeks, 6 weeks, 7 weeks. 8
12 weeks.
12 weeks.
At least 12 weeks.
How about we have no court appearances?
Oh, you're getting
What do
somewhere.
you think, Mike?
Oh, well, I'm going to get a little bit controversial now, and I was hoping the ministry would go to this. By the way, the ministry, I'll get to that point. The ministry did a remarkable thing, which is great. They brought in this form called an enhanced designation. Now, what an enhanced designation is, your client, when they hire you, signs a form, as does the lawyer, appointing that lawyer as your lawyer. It's electronically filed
With the court
with the court.
and the Crown, I think.
Yes. And that gets filed before the first court appearance. And what happens? Your matter can go over automatically 12 weeks. Again, normal steps. You don't even have to go to the first court appearance if you don't. Now, it's a bit risky, to be honest with you, because they're still getting used to the system. I found a couple counties have not
Yeah,
been
we had-
misplacing it.
Yeah, or they hadn't received it. Even though they read our read receipt when we emailed it electronically, everyone's still getting used to things. And then we don't sleep at night wondering if, we're in the middle of our day, we get an email from the Crown saying, oh, the court hasn't received your designation. Meanwhile, they said they did. So it's a little cumbersome still.
Yeah, no, so our current policy, except in a couple counties who insist you don't appear, is because they've lost our designation, I'm still insisting on appearing in most counties.
At the first
And some
appearance.
counties expect it still, even though the rules now provide that you don't have to attend, some expect you do. So what's the great benefit? Okay, go to the first appearance. It can go over automatically 12 weeks.
Save ourselves time by appearing.
Or go or not go.
Yeah.
I prefer to go, except in the counties that don't. over 12 weeks, we don't have these 4 appearances in between. We do all the normal steps which happen normally in a file and move the file. At the end of that 12 weeks, we'll hopefully be in a position to either A, set a date for guilty plea, or B, set a date for trial or preliminary hearing. All the normal steps file. So it begs the question, what do we even need a court appearance for? Why don't we do this? Let me give you an idea, and I think this is used in the federal court system to a certain extent in the States. Why don't we just file the designation, you hire a lawyer, file a piece of paper, and for minor cases, domestic assaults, DUIs, mischiefs, minor property offenses, your expectation is that you do those normal steps in 3 months. Call it even 4 months. Call it 3-4 months. They like you to complete that. Now, if you don't complete those steps, you can do you can report to the court in a simple email saying, look, we need more time because the police haven't provided the disclosure. Okay, we'll grant
That's
you
a
more
great
time.
idea, Mike.
It's simple.
If you were the prime minister, I would instill that.
I got some other ideas, political ideas too. I won't share them on this podcast. But or the other side can say, no, let's say the Crown's ticked off that you haven't moved the file well. So the Crown can agree with you, yeah, they've got a valid reason for needing more time, or no, they've been sitting on their hands. So now the Crown can email the court and say, look, let's get a meeting with a judge or justice of the peace to set some timelines.
Makes sense.
No court appearance still, right?
Yeah.
Never have a court appearance. And the only court appearance would be if you miss your timelines, now you got to meet with a judge and get yelled at. So
like move it along.
Yeah, move it along. So this is a system that can work. I do like the enhanced designation. That's working well because what's happening, we're going over 12 weeks. We're completing our steps. We don't have to have these multiple useless court appearances.
Let me ask you this, Mike. If something transpires, so say the matter goes over 12 weeks, but amidst that 12 weeks and you do get your disclosure and you do meet with your client and say, we know it's going to be a guilty plea, but the next court date is not for another 3 weeks due to the 12-week adjournment initially. Are there steps that we can do, obviously, to deal with that, bring the matter forward? Is that a big process, simple? What can clients expect if that should happen to be the case?
Simplest process in the world, Jody. What would happen in that case if I get the disclosure and the client wants to plead guilty, let's say it's a DUI and they want to stop their 90-day suspension clock, administrative roadside suspension. They want to start a new clock in order to qualify for streaming ignition interlock, which I review in another podcast if you'd like to watch it.
Stay tuned.
Stay tuned for that. So I can simply quickly meet with the Crown to negotiate the best deal I can, report to the client. Client wants to plead guilty. Next day I can call or email the trial coordinator. Can you get me into guilty plea court? Yeah, we'll bring it forward and do the guilty plea next week.
Yeah,
boom, boom.
Guilty plea, bring forward applications, and then the trial coordinator provides us with a date. So
exactly.
So it can be done. So no need to worry about it going automatically over. And then should a decision change in the meantime and somebody needs to plead guilty or wants to plead guilty, or we need to do a bail variation or something like that, they always have bring forward applications for these purposes.
Yeah, absolutely. And again, my contention, and it may be controversial in Ontario, maybe it's not, we don't need any court appearances.
I think it's a great idea. I think we may get there one day, but not right now.
But aren't we almost there with the enhanced designation? It's one court appearance.
Well, we are. I mean, but if we had one piece of paper and the agreement was that we could put it over for 5 months, that would be perfect.
Well, that'd be perfect. There'd still be an expectation that, how about this? There'd still be an expectation that you get it ready within 3 to 4 months. If you're not ready and it's your fault, that delay goes against you.
I have an idea.
Go
How
ahead.
about we prepare a new enhanced designation with a 4-month adjournment. And within that enhanced designation, we itemize number that the defense counsel and client who both sign it agree to within, and this has to be an agreement on the Crown too. So of course, they have to up the ante in getting disclosure to us in a timely manner. So within 3 weeks, you receive disclosure. So that's the Crown's obligation. And number 2, defense counsel then has their next obligation, which is within 6 weeks, receive and review disclosure and have a resolution meeting with the Crown. So those steps can be set out in the enhanced designation. If you do not abide by those, then you guys are getting the strap.
No, that's fair enough. But all kidding aside,
But you go to then case management if those things aren't met.
Yeah, in other words, you have to speak to a justice of the peace
Yeah,
about why they're not met.
like a judge is going to scorn at you.
Or write a letter explaining why they're not met. And Jody, those steps are already implicitly required. Our courts already
Well, before
require
we
those
set a
steps.
trial date, yes, absolutely. We have to have a meeting with the Crown. We have to have a meeting with the judge if
Yeah.
it's longer than 4 hours. So there's no reason why, you're right, those steps cannot be implemented.
I will say this, now for a minor case, maybe 3 months, 4 max is a good timeline for remand court. I can tell you for complex cases like a murder case,
Oh, much
aggravated
different.
assault,
Yeah.
there's different timelines that apply.
Different, yeah.
So that should, the Crown and defense should have more time in the remand system.
Yeah, I
So-
think we're just referring to kind of more simplistic
Yeah,
DUI criminal
absolutely.
cases. Yeah.
But, the important thing for us and for clients, we need to explain this to our clients because they think these court appearances are so important. Oh, how did the
we
court
do
appearance?
our best. We do our best. But you know what? Honestly, Mike, sometimes people, when they first reach out to us, they are so stressed out about even the fact that they have unfortunately been charged. And so, I mean, I, for one, and I know the girls do too, we do our very best at trying to be, very detailed in our explanation and hopefully they're absorbing what we're saying. But we're finding that sometimes, due to the stress levels, and even though they say they understand, then the next day they call and they have like a gazillion more questions, which is something we just, whatever. So the stress kills people. Even though we try to, it's a very stressful situation for them. So the best and easiest way we can explain them, I always say, look, that first court date means nothing.
Right.
There's going to be a succession of further dates that are going to be held, which we will appeal for you. And the reason that enhanced designation is in place is so we can take care of everything for you until you absolutely need to be in court. And you will know that when we tell you when.
Yeah, absolutely.
So it's great. Get a lawyer because we will take care of all that stuff for you guys.
Absolutely. And I don't want to be critical of ministry because I think the enhanced designation is a good thing. I think it's a good start.
It can be improved.
If that's all they do, well, fine. It's a lot better system than they have.
Mm-hmm.
At least they've
It's a start.
they brought us into the late 20th century. I'd like to bring in the 21st century. Electronic appearances,
Mm-hmm.
no court appearances, unless you extend beyond the timelines.
Well, then you have to get electronic too, Mike, because you still want traditionally everything printed and put in your file.
I like both. I like the paper and I like the electronic file kept as well. This is a very interesting topic. I hope I haven't been too controversial, but I wish the ministry had listened to me on this one. Maybe we could make some improvements, and maybe some people disagree with me.
Great topic, Mike. Great topic.
Yeah. So, thanks for meeting with me again, Jody. As usual, I've been really enjoying
No
our
problem, Mike.
podcast series. And, to all the viewership out there, thanks for joining us. I hope you're getting something out of these videos or these podcasts, and I hope you join us on our next upcoming ones. I really hope you enjoyed our podcast. We are absolutely committed to bringing you informative and interesting criminal and DUI content. If you're watching this on YouTube, I ask and encourage you to like this video and subscribe to our channel. If you happen to be an audio listener, please follow us and stay tuned for more great content. If you've been charged with a criminal offense or a DUI in Ontario, please call us or reach out to us online with the contact form found at kruselaw.ca.